Good day, everyone. This is Crime Talk. My name is Scott Reich. This is the weekly recap of all the top stories conveniently located in one location right here. I hope you enjoy it. We'll see you next week. Is Alec Murdaugh going to get a new trial? Well, attorneys for Alec Murdaugh have filed a motion for a new trial citing evidence of jury tampering by a court official. Pretty bold allegation. Well, Murdaugh's attorney said today, quote, "Today we filed a petition based on newly discovered evidence with the South Carolina Court of Appeals to stay Murdaugh's appellate process that is taking place while they ask for a hearing to be held on the motion for a new trial." Concurrently, they have sent a request to the South Carolina United States Attorney to open a federal investigation into the alleged violation of Alec Murdaugh's civil rights. Now, in their motion for a new trial, Murdaugh's attorneys say that the Colleton County clerk of the court in the motion for a new trial, Murdaugh's attorneys allege that the Colleton County clerk of the court, a woman by the name of Rebecca Hill, frequently spoke with jurors about the trial, often remarking about the defendant's presumed guilt and pressuring them to quickly dispense of his case. Specifically, during the trial, it is alleged that the Colleton County clerk of the court, Rebecca Hill, instructed jurors not to be misled by evidence presented in Mr. Murdaugh's defense. That's according to the allegation filed by Murdaugh's attorneys. We'll have to wait and see if there's going to be a response by the prosecutors. It's also alleged that the clerk told jurors not to be fooled by Mr. Murdaugh's testimony in his own defense. Ms. Hill had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself, at the request of Ms. Hill. Now, Murdaugh's legal team also bases their allegations on details from jurors themselves in sworn affidavits that have been filed with the motion. Now, the motion offers additional sources for the actions allegedly taken by the clerk, included a witness to juror interviews, testimony at an in-camera proceeding, and other evidence that we'll have to wait to see to get. Now, Murdaugh's attorneys claim that Hill, the clerk of the court, repeatedly tampered with the jury and the levers of the Palmetto State Justice in service of cash. Now, Ms. Hill pressured jurors, it's alleged, to reach a quick verdict, telling them from the outset that their deliberations, that it shouldn't take them too long, the filing alleges. And Ms. Hill did those things to secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Now, Ms. Hill betrayed her oath of office for money and fame, according to Murdaugh's attorneys. And as you may recall, back on March 2nd, after a trial of some 6 weeks, Murdaugh was found guilty by a jury there in the Colleton County Courthouse. He was convicted of killing his wife, Maggie Murdaugh, and their son, Paul, down there by the dog kennels at their hunting house called Moselle. Now, there were certain timestamps on that decision at about 6:41 p.m. Eastern Standard Time. Ultimately, jurors spent just shy of 3 hours of deciding Mr. Murdaugh's fate after a 6-week trial. Now, what I think is also interesting is that the attorneys for Mr. Murdaugh sent a letter to the United States Attorney requesting a federal law enforcement investigation. It alleges that Ms. Hill was a state actor in violation of the United States Code, Section 18, United States Code 242, by tampering with the Colleton County jury. And they ask that even if no federal charges are ultimately brought, that a thorough investigation by the Federal Bureau of Investigation needs to take place to uncover or discover the truth and to vindicate Mr. Murdaugh's federally guaranteed right to a fair trial. The attorneys allege that the professionalism and integrity of the FBI agents are unimpeachable. Well, it depends on who you ask. Anyway, FBI agents will not attempt to direct the outcome of the investigation by pressuring or deceiving any juror or any other witness. So in short, they are requesting that the FBI investigate the allegations because, well, Alec Murdaugh's attorneys believe the FBI is beyond reproach. And unlike SLED, which is so tainted as it relates to Mr. Murdaugh, that they can't be trusted. Now, we'll see. Obviously, this is a big allegation. It's another allegation to actually back things up. I haven't seen it yet, but I would be interested, very, very interested in seeing the affidavits of the jurors. And if there has been some influence, well, guess what? Alec Murdaugh may get a new trial. We'll have to wait and see.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
Now, we talked about this last night because that's kind of when the news broke. You can listen to our live that we do every Tuesday night. And it was a pretty good show last night, if I must say so myself. Anyway, Lori Vallow and her attorneys have filed a notice of appeal. Now, obviously, Lori Vallow was sentenced to life in prison without parole in July for the deaths of her two young children, JJ and Ty Lee. And she was also found guilty of conspiring to kill Tammy Daybell, the now ex-wife of her husband, number 5, Chad Daybell. Well, anyway, she has to file a notice of appeal. That's simply a notice saying, hey, district court, prepare the record, and appellate courts, be prepared for the record coming your way. That's all it simply is. But it has to be given in a particular time period, otherwise the appeal is waived. So the attorney, whether they think it will prevail or not, must file that notice of appeal. Now, in the notice of appeal filed Thursday, Jim Archibald, Vallow's lawyer, asked the appellate courts to consider some 16 issues. And some of those issues are whether the district court judge, Stephen Boyce, erred in finding Vallow competent for trial after she spent 10 months in a mental hospital, whether Boyce erred in denying Archibald's request to send Ms. Vallow back to the mental hospital rather than proceed to trial, whether the prosecutor's request for a continuance violated Vallow's constitutional right to a speedy trial, and whether Boyce erred when he allowed prosecutors to present evidence of crimes in the pending Arizona case concerning the death of Charles Vallow, Daybell's fourth husband, or Vallow's fourth husband, and the attempted murder of Brandon Boudreaux, Vallow's former nephew-in-law, and whether Boyce abused his discretion by sentencing Daybell to serve 3 consecutive life sentences without parole, whether Boyce abused his discretion by ordering Vallow, who is indigent and has a public defender, to pay $165,000 in fines and court costs. We'll see if any of those prevail. I think the biggest issue is also the whole speedy trial matter. The court set Lori Vallow's trial date beyond the scheduled speedy trial date after the case had been severed from Chad Daybell's matter. That, I think, is going to be the best issue for appeal. Lori Vallow remains in custody at the Pocatello Women's Correctional Center. And the trial for Chad Daybell, her fifth husband, well, that's scheduled to begin on April 1st there in Idaho. Now, the state of Arizona still plans to extradite Lori Vallow in regards to the conspiracy to commit murder as it relates to Charles Vallow's death and for the attempted murder of Mr. Boudreaux, Brian Kohberger. And as I said in the intro, he may just get the genetic genealogy information he is requesting. Well, what exactly is he talking about? Well, as you recall, back in August 18th to be exact, Bryan Kohberger had a hearing. And they had a hearing saying that they should be entitled to get the information that the Idaho State Police as well as the FBI used in obtaining this genealogical information that they used to ultimately create a match as it relates to Bryan Kohberger. As you may recall, Bryan Kohberger's alleged DNA was found at the crime scene of the 4 young college students. They put the DNA profile that was developed into the CODIS system, which is the governmental database for DNA. It's basically people that have been previously convicted of a crime. It goes back to a federal act started in 1994. Well, the problem with that is if the person has no criminal history, they're not going to be in the CODIS system. So the police then took the information that they have, and they went to some private genealogical companies and said, hey, we have this profile. Can you help us out? They ultimately lead to a profile of a family member of Bryan Kohberger. They need to try and match it. So what do? They get the pizza box from his dad, develop a DNA profile. They take that profile, then they take that profile back and they compare it to the lab where they ultimately use that to establish the profile and determine that it is in fact Bryan Kohberger. They match the DNA profile on the knife sheath, and then he gets arrested. Well, like any good defense attorney is going to say is, well, I guess we should just trust everything the government has done up to this point and good to go. No, Bryan Kohberger's attorneys are saying, hey, that's really interesting how you got that information. And some of that, well, you may have done some unethical things to actually obtain that information. And the defense is asking for, and they've called expert witnesses as to why they should get this information. They're not asking for the entire genealogical database. They're simply requesting for the profile that was created from that genealogical database. The prosecution says they have it. They say they'll turn it over to the defense, but they want a protective order. The defense says we'll do it, but yet the state is still fighting it. So anyway, at that hearing on August 18th, there was 4 expert witnesses that testified for the defense. The prosecution cross-examined 2, and they basically said we want to reserve cross-examination for 2 of those witnesses at a later date. The court allowed them to do that, which is really surprising. You would think they'd just be like, the witness is here, you knew you had a hearing, cross-examine away. But the court didn't allow that to take place. Well, the prosecution filed a notice saying we're not going to cross-examine those witnesses. And what they did was they provided a transcript to another case there in Idaho, a case by the name of State v. Dalrymple. Darmiple? I don't know how to pronounce it, but that's the name of the case. And in that particular case, they were seeking a protective order relating to a database that produced information leading to the defendant's arrest. However, the judge in that one was a little bit different because they didn't have the benefit of the expert testimony relating to the forensic investigative genetic genealogical process. And the defense notes that it's noteworthy that even without the benefit of that testimony, the judge concluded that the state needed to turn over in discovery everything in their possession relating to the genetic genealogy, and the defense was welcome to bring further motions on that issue. And the defense clarifies in this particular pleading that they've filed in response, saying that Mr. Kohberger is not asking for the genetic genealogical database, rather the analysis and the documentation used to identify him. Mr. Kohberger has also asked for the NSP profile, and the state has agreed to provide that. That's significant. The NSP is like it's the match that they came up with, and the defense should be able to have access to that, and the defense should be able to have their experts look at it. And why? Because they use that to establish probable cause to go get the 41-1 DNA order so that they can get Bryan Kohberger's DNA to test it to the profile that was developed from the sheath. Well, if there's a flaw in that, then they may not be able to use the DNA because, well, the affidavit may have been made in reckless disregard for the truth. It's kind of interesting. Now, in this filing by the defense, it's kind of lengthy. There are actually several articles in regards to some of the sketchy things that go on when it relates to your DNA genetic database that you send off to the various private genetic genealogy companies that they're going to match you with your profile to see where your genealogy lies. Yeah, they can get around the information that they say is going to be private. Some questionable things go on ethically. And then they also produce a copy of the United States Department of Justice interim policy as it relates to forensic genetic genealogy, DNA analysis, and searching. And they go through and explain why various things are done. You need to comply. And, you shouldn't do things that aren't legally and ethically done in order to get a conviction. Oh, that's right. That's what we do. Now, like I said, don't get me wrong. Do I think Brian Kohberger is innocent? Well, we'll give him the presumption of innocence. We will. But there's a lot of evidence pointing towards him, and the fact that his DNA was there, assuming that is his DNA, that's a bad fact that he may have to overcome. His attorneys are doing everything they're supposed to be doing, and that they're entitled to see the information that the government relied upon to create the affidavit, to create probable cause to get him arrested, and to ultimately compare the DNA match to the sheath as it relates to Kohberger that they're saying. The bigger issue is why is the government fighting this? Why? Now, one thing I've learned in litigation over the last 28 years, ladies and gentlemen, it's not what they give you. You spend most of your time fighting for what they're not giving you. And then you have to ask yourself, why are they not giving the information that they have and they won't produce it? Now, I don't know what's going on, but it makes you wonder, why do they not want the defense to have that? The suspected Gilgo Beach serial killer suspect, Rex Heerman, is now facing an investigation into whether he's responsible for yet another murder of a prostitute near the Long Island home that dates back to 1989. As you may recall, Heerman is charged with the first and second degree murder in connection with the death of three victims, Melissa Bartholomew, Megan Waterman, and Amber Costello. Now, police say he is the prime suspect in another killing that related to Maureen Brainerd Barnes, and he is now being investigated in connection with the 1989 murder of sex worker Carmen Vargas, whose body was found near Heerman's home. Now, Vargas was later found dumped on the side of the Meadowbrook Parkway, just 7 miles from Heerman's Massapequa Park home, and her body was beaten and bound. Now, the suspect, thought to be the Long Island serial killer Joel Rifkin, who denied it back in 1993, despite copying to some 17 other killings at the time. Now, apparently Joel Rifkin said, "That's not me. That's not my work." I guess we're going to find out if it's Heerman's work. Obviously, we give him the presumption of innocence, but, we'll just have to wait and see.